Well, hello everybody. Hello. Today we'll start the Indian Evidence Act.
Okay, sir.
Before going to the sections as such, I have material given for sections also. I'd like to give an overview and important items in a more, kind of essay fashion, so that you will know where each of these sections lies and what is its relevance. So let us first start. We have what is called as Indian Evidence Act. Now, what is the most crucial word in that Indian Evidence Act is evidence, right? Now, what is evidence and why evidence is necessary and how evidence has to be brought up and how it is to be evaluated and on what is the result of an evidence that is being presented. These are the 4 or 5 logical questions that flow from the word evidence. So, under Indian Evidence Act, evidence refers to any information, material or fact that is presented before a court to establish the existence or non-existence of a disputed fact. A dispute is all about a fact being there or not there. So, if you present something in support of your contention that a fact is there or fact does not exist, the fact exists or fact does not exist, you give something in support of that, then that is called evidence. Now, what is it that you proffer before the court? It is information, it is the materials, it is the facts. Okay, now there are actually 4 types of evidence available to us. First and foremost, as you know, is a person coming and telling you that this is what I believe to be, this is what I saw to be, this is what I have done, something like that. All these 3. So that's called oral evidence. Next is the documents that are produced, your birth certificate, death certificate, property registration, sale deed, agreement for sale, all things like that. These are all documentary evidence. Okay? Third is material evidence. Material evidence, the knife with which a murder has been made, poison that is administered, or the pesticide bottle, things like that, or the body itself if a person has died. These are all called material evidence. Now the 4th one has recently been added, that's called digital evidence. Digital is everything that is online, everything that is available, digital documents, digital evidence, digital transaction, digital contract. So essentially you have to remember that there is something called evidence. There is something called a fact, and the fact either exists or does not exist. Existing of a fact is also a fact, and not existing of it is also a fact. Remember that. Fact always does not mean only existing. Fact means either existing or not existing. Okay? Now, existing of a fact, not existing of a fact, that is one thing that happens. Then to prove this particular state, you give 4 types of evidence. The 4 types of evidence are: number 1, oral evidence; second, documentary evidence; third is the material evidence; and 4th is digital evidence. These are the 4 evidences. And then finally, what should be the level of evidence? Again, what should be the seriousness with which that particular evidence is presented? What should be the finality attached to that evidence? And that is called, there are 4 rules here again. One is admissibility. You have to present an evidence that is admissible under the law and the rules meant by the court. You cannot present something that is not acceptable to the court. As simple as that. Not acceptable to the law, again as simple as that. Next, relevancy. Whatever evidence you produce should be relevant to the disputed fact. The fact that is the subject matter of the court case. If you present something completely out of the way, this has nothing to do with whatever we are discussing, then that's a waste of court time. So, relevancy. Third is weight of evidence in Indian courts. What is the importance? What is the weight to be attached to each of the evidence items that you are presenting? So, admissibility, relevancy and weight. The weight can also be called probability, right? It can be may is 50% probable, then certain is 100% probable, everything in between is shall, should, वगैरह, all kinds of things. Okay? So let us see where this evidence is defined under Indian Evidence Act. It is defined under section 3. That number section 3 you have to remember. Now what does it say? Section 3. All statements which the court permits or requires to be made. There are two things that the court does. One, you go and say, sir, I want to present this evidence. The court says, okay, permitted. Second, the court itself will say, okay, bring all these 1, 2, 3, 4, 5 evidences before me. Requires to be made. This to be done by whom? Presented by whom? Number 1, by witness. Then documents and other things should be in relation to the matter of fact under inquiry. All documents to be produced before inspection of the court. Any matter observed by any of the senses, 5 plus 1 senses. What are 5 plus 1 senses? We have 5 senses and then the mind. 5 senses is eyes, ears, touch, taste, वगैरह, all 5 senses you have. Plus mind. 5 plus 1 senses. How many senses we have? Normally you say we have only 5 senses, but legally we have 5 plus 1 senses. So any matter observed by any of these 5 plus 1 senses, and anything that is subject of perception. Now evidence can be oral, it can be documentary, it can be material, and then next is it can be digital. Oral evidence refers to statements made by witnesses during their testimony, either in examination chief or cross-examination or re-examination. There are 3 kinds of examination a witness goes through. One is examination in chief, the first time he enters the box. Second is cross-examination, when he is cross-questioned by the opposite party. Then re-examination, when he is re-examined by the party who is presenting him to clarify the issues that have been raised in the cross-examination. Next comes documentary evidence. Documentary evidence includes anything written, printed, and documentary electronic evidence includes electronic documents, contracts, letters and reports. Then comes material evidence. Material evidence relates to objects, things like weapons, photos, physical evidence, or in the body itself. Indian Evidence Act sets forth the rules regarding the relevancy, admissibility and weight of the evidence. It covers various types of evidence like direct evidence, indirect or circumstantial evidence, expert opinion, hearsay evidence, confession and much more. Now what are all these things? Let us see from back to front. One is confession. Confession means if I have committed a crime and I go to the court and say, yes, I have done it, then that is confession. And it should be done before a court or a magistrate, remember. Whatever confession you make before the police is of no use. It is not admissible. Second is hearsay evidence. Hearsay evidence is, I have 5 plus 1 senses. Within these 5 plus 1 senses, one that I only hear, I have nothing. That issue or the act that has actually happened, I have not perceived with any of my 5 plus 1 senses. But somebody else has perceived and that fellow told me and I am telling it to you. So it is a second hand, third hand, fourth hand information. That second, third and fourth hand information is not admissible in a court. So that's called hearsay evidence. So any evidence orally given must be first checked for being hearsay evidence. Next is expert opinion. Opinion normally is hearsay evidence, and as being a hearsay evidence it is not admissible, except the exception is given in case of experts. You are all forensic experts, so your opinion will come under this expert opinion. So that is admissible as an exception to hearsay rule. Next comes direct evidence and indirect evidence. Direct evidence is what I perceive with my 5 plus 1 senses, and then tell the court that I have perceived with these senses and this is what I understood, this is what it is. That is direct evidence. Second is circumstantial evidence or indirect evidence. All forensic evidence, all forensic reports form part of the circumstantial evidence or indirect evidence. Okay? The court evaluates the credibility, reliability and probative value of the evidence to arrive at a just and fair decision in a case. So court, what does it do? It takes care of the credibility, whether the witness who is coming before me is a credible witness or not. So the opposite party is always given a chance to break the credibility of the witness. Second is reliability. Reliability means if I say X today and after 10 years or 1 year or 2 years again I say that it is X again, and again after 5 or 10 years again I say it is X, that is called reliability. That means the court can rely on you to say X to be X at any given point of time, however long the difference in between may be. or whoever may ask you the same question, you will still say the same thing. That is reliability. Then probative value. Probative value I told you, may means 50%, certain means 100%, in between is 50 to 100, it can be shall, should, vagara, vagara. This is the probative value of the evidence to arrive at a just and a fair decision. Now, what is the duty of the court? The duty of the court is a judge, adjudication. Adjudication means being just and fair. Just, fair and reasonable. These three words, please remember. JFR, like JFK Kennedy, JF Kennedy, similarly JFR. JFR is just, fair and reasonable. Every judgment, every action of the court has to be just, fair and reasonable. If these three tests are applied and he passes, the court is a very good court. Now, next thing. Let us see the rules of relevancy under Indian Evidence Act. We said relevance, they will find out now what is the rules of relevancy. There are provisions under Indian Evidence Act regarding rules of relevancy which determine the admissibility of evidence in courts. These rules specify the conditions where the evidence proffered is considered relevant and get presented before the court. Now here, 5 to 55, these are sections. What are the sections that cover the rules of evidence or relevancy of the evidence? Are section 5 to 55. 5 to 55, all the details are given, 50 sections are given, which indicate how a particular evidence is relevant to your particular case. So, whenever you are presenting a particular evidence before a court, you will have to quote from this 5 to 55 under which section it is relevant. If you are able to satisfy the court that the evidence that you are proffering, you are giving to the court, is relevant under 5 to 55 any one of these sections, then that is a relevant evidence. Okay? But relevant only 5 to 55 only and nothing else. Please remember, the Evidence Act is a very, very strict act and it does not allow any deviation from 5 to 55. 5 to 55 is what makes it relevant, and if it does not cover under 5 to 55, it is thrown out. That's all. Now let us see section 5. 5 says facts which are occasion, cause or effect of relevant facts. Relevant fact, there is a fact and it is relevant to a particular case, right? Then there are things that are all around. Things that are all around. They are called occasion. Occasion for that relevant fact. Then you have cause. Items that cause this particular relevant fact. Then effect. Then that are things that come after the act. See, there is an act. Okay. There is something that is going all around the act, that is called occasion for the act. There is something that caused the act, this is called the cause. And there is something that come after the act because of the act, that's called effect. So occasion, that is all around, cause before it, before the act, effect, that is after the act and the act itself. These are relevant facts. This rule states that any fact that is occasion, cause or effect of a relevant fact is relevant. It allows for inclusion of facts that are connected to the main issue and help in understanding the context. Now section 6 to 55 is relevancy rules, I told you. Now facts which are relevant to the existence of a fact in issue are a relevant fact. Now there are two words again here. One is fact in issue, second is relevant fact. Fact in issue is the point that you raise in a court as a point of dispute. You are going to a court, you are raising a dispute. And the item that you are raising a dispute for or dispute with is called fact in issue. And all the other items that are supportive to the point in issue or a fact in issue are called relevant facts. Now these sections list various categories of facts that are relevant to the existence of a fact or a fact in issue or a relevant fact. Let us see the examples. First, admission under section 17. Admission means I admit. Supposing two brothers go to a court saying that we want our property, my father's property, to be partitioned among us. So first step they say is we have a common father, we agree that we are brothers, we have a common property and this property has to be distributed amongst us. And there is a dispute amongst us as to how much I will get and how much he will get. So the dispute is the proportion in which each of them will get. But what is admitted is that there is a common father, there is a common property and that they are brothers. These three things are admitted. So this is called admission. Statements made by a party to the proceedings or by someone authorized by the party, that is the agent or a lawyer, which are against their interest and tend to prove the case against them. These are called admissions. Okay, the moment I say I am come to a dispute, I want the entire property, but still I say that this property is common to me and my brother, so that actually goes against me, but still I agree to it. That's my admission. Now, statements made in documents produced for inspection, that is section 35. Under section 35 it says, whenever you produce a document, you make a statement regarding number one, that it is a document, number two, who gave it, how it is produced, where it is available, how it was brought, who signed it, number three, what are the contents of the documents and how it is relevant. These are the 4-5 things that you tell about a document. That's called section 35. Statements made in documents produced for inspection of the court are relevant if they are referred to any fact in issue or a relevant fact. Next, section 45, opinion of experts. I told you hearsay evidence is not allowed, but expert opinion as an exception to hearsay evidence is allowed. Forensic experts come under this section. It is section 45. Opinion of experts in their respective fields are relevant if they are based on their specialized knowledge and can assist the court in determining a fact in issue. Statements in the course of business, section 32. Here, statements made by a person who has a special knowledge in a particular subject in the regular course of business, like a banker regarding banking, or a goldsmith regarding goldsmithing, like that, anything, okay, or let's say a driver regarding driving, mechanic regarding machinery, an engineer regarding whatever project is done. So these are all things, statements done in course of business, especially a banker giving a statement of account regarding the things that are happening in a particular ledger account of a customer. That comes under this, essentially. Statements made in the course of business, section 32. Next is section 56, facts not otherwise relevant but connected with relevant facts. There are some things which are given by itself are not relevant, but because they are connected to relevant facts, they become relevant. This rule states that the facts that are not otherwise relevant but are connected with the relevant fact become relevant. It allows for introduction of facts that have a logical connection with relevant facts and can help in establishing a truth. Supposing we are trying to find out whether a particular person is there in Hyderabad on a particular day or not, or is there in Pune on a particular day or not. The fact that he has booked a ticket, there is a ticket in his name, as a railway chart, in the railway chart there is name against a particular berth, and then a hotel booking is there in his name. All these things are actually hotel, train, reservation chart. They have nothing to do with what you are trying to do, but they become relevant because they establish a person's presence in a particular city where a crime has occurred. So that's how they become relevant. That's called section 56. Next is section 57. Facts of which court must take judicial notice. There are some things which you don't have to again go and prove before the court. Sun sets in the west, sun rises in the east. Okay, in India has got an ocean on 3 sides, and then one side there are Himalayas. These are things which you don't have to prove by way of any proof. You don't have to see with your 5 senses and mind to find out it is true or not. It is for the court to take a judicial notice. It is for the court, it is general knowledge. The court should know. So these are the things that come under section 57. This rule deals with facts that the court is required to take judicial notice of without requiring any formal proof. That is, existence of Indian Penal Code, Constitution of India, public statutes, India being, a subcontinent. There are some of the key rules of relevancy. Let us see. There are the above others. No. Now let's see what is an expert. Section 45 we said. Section 45, let us see. An expert witness in the context of legal proceedings is an individual who possesses specialized knowledge, skills or expertise. Yes, 3 things. 1, specialized knowledge, skill, expertise. These 3 things in a particular field. How will you get it? Knowledge by doing or by learning or by observing, that you get knowledge. By studying, by qualification, by certification. Skill is only by doing. More and more years you do work on that, you become skilled in that. And expertise, that means you are the only fellow who is doing that. Nobody else has done it. So that is expertise. So that is a particular field is relevant to the case in hand. Expert witnesses are called upon to provide their professional opinion or judgment regarding complex or technical matters beyond the understanding of an average person. Here the rule is average person. And a court or a judge is considered to be an average person. Remember that. The role of an expert witness to assist the court in understanding and evaluating evidence that requires specialized knowledge. Their opinions are based on their expertise, qualification, experience in their respective fields. Expert witness can be professional like doctor, engineer, forensic scientist, forensic psychologist, accountant, or any other individual with a specialized knowledge, even a goldsmith. There is no requirement that an expert has to be well read, that he should be MA, BA, CA, vagara, no, nothing like that. If he has a specialized knowledge, that is sufficient. He can be completely, anguta chap, doesn't matter. Expert witnesses are typically called upon by either party in a legal proceeding, and their opinions are presented in the form of expert evidence. They may be asked to analyze evidence, offer opinion, interpret data, provide explanation regarding the subject matter of the case. Now, what does the expert do? Simply he has given in one line. What he says? One, he will analyze the evidence. It is on whatever evidence is given. It may be in the form of statements. It may be in the form of a book. It may be in the form of a Excel sheet. It may be in the form of a series of numbers. So there is a need to analyze that. Okay, somebody has to analyze it. Analyze means either group or regroup or break down, whatever. Analyze it, then offer an opinion, what it is, how it is relevant, what does it purport to be, what evidence does it give, what is the weight of it. Then interpret the data. See, data, that is the numbers or data. This data has to be interpreted to provide information. Information is to be used in the court by the judge to decide this particular case, the interpretation of data. Then provide explanation. If there is a phenomenon is there, that phenomenon, how does it happen? How does it come about? That explanation has to be provided by the expert. Expert witnesses are expected to remain impartial, objective. Just because the police calls you or the prosecution calls you, you are not bound to be partial towards the prosecution. You are not bound to give a subjective opinion. You have to be objective, you have to be impartial and present their opinion based on sound scientific principles, professional standards and their own expertise. Okay, you should base yourself on sound scientific principles, professional standards, ISO standards, vagara, and their own expertise. Court considers the expert witness qualification, experience, reliability of the method and opinion when evaluating the weight and credibility of their testimony. So what do you understand in this one particular line? Essence of expert witness is here. Now one, first an expert is there, he gives testimony. The testimony has to be credible and then court has to understand how much weight they have to place on this particular testimony. And this definition or this decision of the court in evaluating how much weight to place on the testimony is based on what? Is based on the qualification of the witness, his experience in the field and the reliability of his own opinion and the methods that he uses to arrive at the opinion. These are the 5 or 6 things that are very much necessary to know what an expert witness, whether his opinion is accepted and the decision is passed on that or it is set aside. However, it is important to note that the ultimate decision on the admissibility and weight of expert evidence lies with the court. See, court is the expert of experts. What they say? Court is an expert of experts. That means court has the right and the ability to sift through good expert and a bad expert and accept a good expert with a solid evidence and leave away the bad expert or a pretentious expert with a shaky evidence. Get the idea? So you don't not only necessarily have to be an expert, but you also have to have good methods and you also have to have good procedures. You also have to have good record of whatever you have done and present it to the courts in a manner that is understandable by an average person of average intelligence. Then the court will accept you as a good expert and take your evidence into account. Expert witnesses play a crucial role in assisting the court in understanding complex issues and make informed decisions. Their testimony can significantly impact the outcome of a case by providing specialized knowledge and insights. Now, what are the examples of questions put to expert witness in examination in chief? This will come again. Now we have introduced the subject. We have Indian Evidence Act, we have seen. Evidence we have seen. Okay. Now let us go back to sections and come back to this again. Remember, this is under 69. We'll come back after seeing the sections. Otherwise, we'll miss the sections. Yeah, let us see. First, section 32 of Indian Evidence Act. We have already seen that 5 to 55 are the relevancy rules and section 32 forms part of the 5 to 55, that chapter. So So this is also a rule of relevancy. Remember, Section 32 of Indian Evidence Act is a rule of relevancy, and Section 32 of the Indian Evidence Act deals with cases in which statements made by a person who is dead or cannot be found are relevant. That is called dying declaration. The one word for it is dying declaration. Okay. Now Section 32, that means normally a person who comes to the court is a living person. He comes into the witness box and then states in his own words, using his own five senses and the plus one mind. But here in this case, you take into account what is said by a person who is already dead and gone, and you cannot get him. Okay? So that is called dying declaration. Here, these are the statements made by a person who is dead, okay, about the cause of his death or to any circumstances that result in their death or relevant in certain situations. They are admissible in criminal cases and inquiries into a person's death. In the inquiring into it, they become relevant. What are the cases? Koli Lakshman Bhai Chana Bhai versus State of Gujarat, 1999. Supreme Court held that the statements made by a person before his death, disclosing the cause of his death or circumstances leading to his death, are admissible under Section 32 of the Indian Evidence Act. The importance of examining the statement in entirety and considering the surrounding circumstances to assess its reliability. Now, what it said is number one, that the person should be dead now when the court is examining. Two, he must be just before his death, he must have made this statement to a magistrate, and then he should have made it, okay, regarding the cause of his death or how he came about to die. What are the circumstances leading to his death? And then he should be in his senses. He should know that he is going to die, or he may not even know, but that finally he may die. That he should consider all these facts before him and put it before the others, before a magistrate, a reliable person, so that this is taken into account later on in the court. Get the idea? Next question is Krishna Mochi versus State of Bihar, 2002. Supreme Court reiterated admissibility of dying declaration under Section 32. Dying declaration made by a person on the verge of death and having no hope of recovery are given high evidentiary value because they reflect a person's solemn and conscious mind. Here, the rule is that no man would like to meet his creator with a guilt in his mind. The rule is no man would like to meet his creator or the God after dying, after death, with a lie in his mouth. That means no man would like to lie, would like to utter a falsehood just before death. But okay, that is the rule, that is the presumption of law based on which a dying declaration is made relevant. Okay, there are maybe exceptions cases where, let us say, a husband killed a wife, but the wife is fond of the husband. So before dying, she says, my husband has no role in my death. Then there was only a kitchen accident in which I have died. So my death has happened. So such things are possible, but still in 99 out of 100 cases, 99 out of 100 cases, a person speaks out the truth just before death, knowing that he is going to die. Okay. Next, S.K. Jalaluddin versus State of Kerala, 2014. Supreme Court discussed the requirement for admissibility of a dying declaration. He said to be admissible, it has to be number one, voluntary, second, truthful, third, reliable, and should inspire confidence. That's the fourth one is very, very tricky. It should inspire confidence. Confidence of whom? Confidence of the court. The court emphasized need for proper corroboration with all the circumstantial evidence to be held genuine or truthful. These cases provide important interpretations. Okay, next. This is Section 32, dying declaration. Next is 45, Indian Evidence Act. This is related to expert opinion, expert witness. An expert opinion or opinion of an expert witness based on the tests or data that is available to him related to a specialized knowledge, skill or experience that he has is relevant in particular case. Has to form, now here the expert has to form an opinion, the court has to form an opinion. Wherever the court has to find out or form an opinion about a foreign law, a science subject or an art, or a question as to identity or genuineness of a handwriting or finger impression, or opinion of experts who are skilled in such matters is admissible in evidence. That means because the court by itself cannot become a master of everything. It can be jack of all trades, but cannot be master of all trades. So they bring a person who is a master of the trade to tell them what exactly they want to know. Okay? Regarding foreign science or law or art or a question as to identity and genuineness. Now the cases, let us see. R versus B.H. Gandhi, 1953. Court emphasized admissibility of expert opinion. Expert evidence can be admitted to assist the court in forming an opinion on matters that require specialized knowledge or skill, like handwriting analysis. Handwriting expert is allowed under that. State of Maharashtra versus Damu, 2000. Supreme Court discussed the admissibility of expert opinion in cases involving medical evidence. Here, medical expert opinion regarding cause of death, nature of injury, possibility of sexual assault can be admitted under section 45. So, postmortem report, the main three things that you look for it is cause of death, time of death, nature of injuries, and detailed information regarding injuries, how they are caused, and then possibility of a sexual assault. However, the court also emphasized that the expert's opinion must be based on scientific principles and not be a conjecture or subjective views. State of Himachal Pradesh versus Lake Raj, year 2000. Supreme Court clarified, opinion of a handwriting expert is treated as substantive evidence and does not require corroboration. Opinion of expert on genuineness or identity of handwriting is relevant and admissible if the expert has followed the scientific methodology. So it's all relevant to your following of a particular methodology. So this is section 45, expert evidence. Next, section 46. 46 is facts bearing upon opinion of expert. That means all the scientific principles, all the procedures, all the materials, all the experiments that you do, and all nature of all the items that you use, consumables or other materials, all these things are facts. They have a bearing upon the expert arriving at his opinion, which he presents before the court. So all those facts, all your experiments, all the data regarding experiments, all the records of your experiments, they become relevant under 46 in addition to your opinion. Facts not otherwise relevant or relevant if they support or are inconsistent with the opinion of experts when such opinions are relevant. So the support can be positive or negative. The question is whether A was poisoned by a certain poison. The fact that other persons who were poisoned by the same poison exhibited certain symptoms which are similar to the one that this person has exhibited are relevant. The question is whether an obstruction to a harbour is caused by a certain seawall. The fact that other harbours similarly situated elsewhere in the world where there are no such seawalls began to be obstructed at about the same time becomes relevant. Section 46 deals with admissibility of fact in support or to contradict the opinion of experts when the opinion of expert is relevant. Otherwise, irrelevant become relevant if they are consistent or inconsistent with the opinion of expert. Now, two illustrations. One illustration A. Case involves determining whether a person A was poisoned by a specific poison. The fact that other individuals who are poisoned by the same poison exhibited similar or same symptoms which experts confirm or deny as symptoms of that poison become relevant. Court can consider symptoms experienced by others to assess whether A's symptoms align with the symptoms of a person who takes that poison. Okay? Next, the case revolves around determining whether a particular seawall is responsible. We have already seen that. So, section 46 allows the court to consider additional evidence that may provide support or contradiction to the opinion expressed by the experts. It enables the court to evaluate reliability and credibility. Section does not automatically render all facts relevant or all facts irrelevant if they are related to expert opinion. Only those facts that directly support or contradict expert opinion in question are admissible. Admissibility and weight are depending on the discretion of the court. Next is section 47. 47 deals with examination of an adverse party. Okay? When supposing I am defense, if I am questioning the police officer, I am adverse party. So I am prosecution, I am questioning the accused, I am adverse party. This is called examination of the opposite party or adverse party. It allows the adverse party to be examined as a witness in a civil or criminal case. Okay, now 47 states that a civil or criminal proceeding, the adverse party who has a direct interest in the outcome of the case can be called as a witness and examined by the other party. This provision allows for examination of adverse parties to bring out relevant facts or challenge their credibility. Let us see the cases. State of Maharashtra versus Abdul Sattar 2000. Supreme Court held that the accused in a criminal case can be examined as a witness under Section 47 of Indian Evidence Act. Here one thing you have to remember is that we have a constitutional protection. We have a constitutional protection against self-incrimination. That means a party need not say anything which will incriminate him, which will put him behind bars, which will put him into any harm or a sentence or jail. So that protection is there. He can say, I refuse to answer the question. But if he says, I refuse to answer the question, then the court is at liberty to take a negative conclusion. Okay? It can draw its own negative conclusion. That those two things are there. One is positive in your favor, the other is negative against you. In state of Maharashtra versus Abdul Sattar, Supreme Court held that the accused in a criminal case can be examined as a witness under Section 47 of Indian Evidence Act. Court emphasized accused has a right to give evidence in their defense and the prosecution can cross-examine the accused to test the veracity of their statement. In Balraj Taneja versus Sunil Madan, 1999, Supreme Court discussed the scope of 47 section in civil proceeding. Court held defendant can be examined as a witness by plaintiff under 47. However, plaintiff cannot be compelled to examine the defendant as a witness and it is within their discretion to decide whether or not to do so. In Sudhir versus State of UP 2012, Supreme Court reiterated the importance of Section 47, held accused has a right to be examined under 47, but his silence, he has a right to be silenced again. His silence during the trial cannot be held against them. The court emphasized that adverse parties' examination as a witness should be conducted fairly in accordance with the principles of natural justice. These Supreme Court cases emphasize significance of 47. Okay? Next, Section 57. All seals of which English courts take judicial notice. The seals you have to take judicial notice. Then accession to office, name, title, functions, again judicial notice. Existence of a title, national flag of every sovereign, judicial notice. Divisions of time, geographical divisions of the world, public festivals, judicial notice. Territories under dominion, judicial notice. Commencement, continuance, termination of hostilities, judicial notice. Names of members and officers of the court and deputies, judicial notice. Rule of the road. Then these are things, all next 57 deals with all the items which court has to by itself, so moto, on its own is supposed to know. These are all part of the general knowledge of the court, which you should not ask the party to prove. There is nothing to be proved there. The moment he says, yes, this is so and so, Draupadi Murmu is our president, court has to accept Draupadi Murmu as our president. It wants if it can go and check the official record, that's all. But you cannot ask you to prove it or present a document for it. Okay? All these things above, listed above, are court has to take judicial notice. 57 outlines various facts and matters of which court may take judicial notice. They include seal of a court, name and function of a public office holder, existence of a recognized state or a sovereign, division of time. We are 5.5 hours after Greenwich Mean GMT, Greenwich Mean Time. So that is given. See, division of time, geographical division. Okay, we are living in Telangana, we are living in Pune, Maharashtra. These are all geographical divisions. It is to be taken. The court has to accept it as it is and use its own brain to accept it. Public festivals, holidays, territories under Government of India, hostilities between India and Pakistan, court members, officers, advocates, authorized individuals, rules of the road, drive on the left, don't drive on the right, things like that. Public history, literature, science, art, these are all things that court has to use its own brain to find out. Then State of Punjab versus Baldev Singh. Supreme Court recognized that the court can take judicial notice of the name, title, functions of public official holders. State of Punjab versus Ratan Singh. Supreme Court held court can take judicial notice of existence, title, national flag of different governments. State of AP versus Kandimella Subaya held that court can take judicial notice of geographical division of the world. Court relied on such division to determine jurisdiction and applicability of certain laws. Union of India versus Ansoli Devi, court can take judicial notice of public festival and holidays notified in the official gazette. So these are all the things under 57 which court uses its own brain to take judicial notice. Now section 58. It pertains to the order and conditions of production and examination of witness. Order in which witnesses are to be produced and examined in court. Okay, this is 58. So witnesses are to be first produced for examination in chief by the party who calls them. First, whoever is calling examination in chief, वो पहला आएगा. Then it is followed by cross examination by the opposing party lawyer, वो बाद में आएगा. Then re-examination by you again, वो third आएगा. ठीक है? Examination chief, then cross examination, then re-examination in this particular order. This is what section 58 says. A structured procedure should be there. जिसका जो मन में आए, जो क्वेश्चन नहीं पूछना है, जिसका जो मन में आए वो बात नहीं करना है. It should be in a particular order. That's 58 says. State of Maharashtra versus Suresh. Supreme Court emphasized importance of following a prescribed order of examination of witnesses under 58. Exam chief, cross-exam, re-exam should be in that particular sequence to ensure fairness and efficiency. Bimla Devi versus State of Madhya Pradesh. Supreme Court discussed 58 of the rights of the accused. Well, accused has the right to cross-examine the witness produced by prosecution in the order specified in 58. Court says the need for adherence to the prescribed procedure. UP versus Kishan Chand. Supreme Court dealt with the issue of non-compliance with the order of examination 58, held that deviation from the prescribed order of examination does not necessarily render the evidence inadmissible, but weight and credibility is affected. Next, section 60. Section 60 deals with the power of the court to put questions and order of production. Section 60 gives the power. Normally in a court what happens? Prosecution brings the witness. He is put on the witness box. Prosecution may ask questions. Then defense will ask questions. Again prosecution will ask some more questions. Issue is closed. Now what is the role for the court? What is the role for the judge? That is given under section 60. Section 60 says there is a power of the court to put questions. It grants the court the authority to ask questions to the witness on its own, suo moto, what it considers to be relevant, and order production of documents or other material evidence. You can say, okay, bring this paper, bring that paper, bring this certificate, bring that material evidence. Court can give all those orders. Section 60 empowers the court to put questions to witnesses, whether during examination chief or during cross-examination or during re-examination. All three stages court has the power. Court has the discretion to ask questions to elicit necessary information, to clarify ambiguity. Court can order production of document, thing or material objects. Cases. Rajendra Prasad versus State of UP. Court emphasized court has the inherent power to put questions to witnesses in order to elicit truth and prevent miscarriage of justice. It has to be fair, impartial and aimed at discovery. Now what is the requirement? What kind of questions you have to put? What is the purpose of such questions by court? Is to bring out fairness, impartiality and discovery of truth. State of Maharashtra versus Sukhdev Singh. Court's power to put questions is emphasized to ascertain the truth by posing relevant questions to the witness. Again, truth. Quest for truth is uppermost. The exercise of this power should be within the framework of fairness and impartiality. K.V. Rajendran versus State of Kerala, 1999. Authority of the court to put questions. Power to compel production of documents are relevant to the case and necessary to fair and just decision. Court has the power to compel the other party to bring the documents. Supposing you are discussing about property division and the first property document which has been created, that is a must. Somebody is holding it. That's a will related to it. That's again a must. Somebody is holding it in secret. You have to force. The court can force him to bring it and show. Next, section 73. 73 is handwriting expert. Comparison of signature, writing or seal with others that are admitted or proved. Okay? There are two things here. One is a questioned signature or a writing. Then you have a standard signature or a writing that is admitted, okay, or proved already. Then you have the sample that is taken, and these three things are compared and proved, and then an opinion is given. So in order to ascertain whether a signature, writing or a seal is that of a person by whom it purports to have been written or made, any signature, writing or seal admitted by him or proved to satisfaction of the court that it is written by such and such a person is useful for comparison, and then that is used so that it is produced or proved for any other purpose. It can be proved for any other purpose. Okay. Next, 73A. 73A is related to digital signature. Proof as to verification of digital signature. In order to ascertain whether digital signature is that of a person by whom it purports to have been affected, court may direct the person or the controller or certifying authority to produce the DSC or to apply public key and check, verify whether that particular thing is correct. Now 73, 73A discussion. Yeah. It is comparison of signatures, writings or seals with those that are admitted or proved, allows for comparison with a disputed signature, writing or a seal with a known or admitted one for the purpose of authenticity determination. The proof of verification of digital signatures is under 73A. Okay, comparison of signature, writing or seal at 73. Compare a disputed signature, writing or a seal with another that has been admitted or proved. Even if the admitted or proved has not been produced or proved for any other purpose, it can still be used for comparison. Course direction for comparison. Court has the authority to direct any person present in the court to write specific words or figures. They can ask, तुम बोलो, तुम बोलो, तुम बोलो, तुम लिखो, ये बाद में लिखो, 4-5 लिखो, 20 बार लिखो. Let everybody see and find out, like that. Court can do. Or court can by itself see, ask him to write 20 times and then see whether that compares. Case law. Now, Dharamdev versus State of UP. Supreme Court held Section 73 permits the court to compare admitted or proved signatures, writings or seals with disputed ones to determine their authenticity. Court emphasized that the comparison should be conducted by experts who possess necessary expertise in handwriting analysis. Then UP versus Harish Kumar. Supreme Court said comparison of signature, writing or seals clarified while expert evidence is not mandatory. In cases where a court lacks the necessary expertise by itself, it should seek the assistance of expert opinion. 73A Indian Evidence Act is added due to digital signature certificate and digital signatures. 73A, there is no significant court cases on 73A. Next, section 135. 135 is order of production and examination of witnesses. Order in which witnesses are to be produced and examined shall be regulated by law or practice. Here, there are two things. In practice, the inspector is to be examined last. The eyewitness is to be examined first. This is the practice that is followed. All others come in between. Okay? First is the eyewitness, then come the relevant witnesses, then come the experts, then finally the inspecting officer or the IO who has done the investigation and given a report. In that particular, this particular thing is given under section 135. 135 does not specifically say so, but it says it is practice, and this is the practice. The order in which witnesses are to be produced and examined should be regulated by civil and criminal procedural laws. Regulation by law and practice in civil and criminal law procedures, every high court brings out its own rules of practice. Rules of practice, high court and every high court will have its own rules of practice. And court also has a discretion. Sometimes the court has to change the rule of practice that has been done in production or examination depending on the exigencies. Supposing somebody, a witness comes, okay, he says, tomorrow I am flying off to America. I already booked 6 months back. My job is there. I have to go back, otherwise I lose my job. Then the court may say, okay, dump everybody else. Let us examine this witness, complete his deposition and send him off. That can be done. Court has the power. Discretion. Now 135. State of Maharashtra versus Damu. Supreme Court held order of production and examination of witnesses primarily governed by procedural laws. CRPC, CPC and then rules framed by the court, High Court. Relevant High Court. Abdul Qadir versus State of Kerala is primarily regulated by procedural laws in force, but it should be exercised judiciously. Court discretion, if it is there, it is used, it should be exercised judiciously, taking into account the interest of justice and requirement of the case. Then 136 deals with the examination of a witness by the party who calls them. Okay, I am calling a party and then I am questioning him. There are two ways. Okay, here especially 136 is relevant to where, supposing I call a witness and then witness comes and gives a evidence that is going against me. That is going against me. Normally, when I am the person who is calling him, he should give his witness statement in my support. But supposing I find that this fellow is going against my interest, then I can ask the permission of the court under section 136 and ask him leading questions and put him in such a situation that he himself will either contradict himself or give out the information which I want. Normally, a person who is bringing the party for first time is not allowed to put leading questions. But under 136, a special permission is given by the court to the prosecution to put leading questions to a party who has been brought by him if that party is giving adverse evidence to him. So, if a witness called by a party gives evidence that is adverse to the interest of that party or becomes hostile, okay, this is in general sense we call hostile witness, but there is nothing, no word called hostile witness given in the Act, please remember. The party calling the witness has a right to cross-examine him. It's not so, not cross-examining is not the right word. He has got the right to put leading questions. He is the right to put those questions which opposite party will put in a cross-examination. That is the wording used in the court. That means, what does the other party use in a cross-examination? That the questions that are used by opposite party in a cross-examination are leading questions. So that provision is given to him. The same authority is now given to this party also to put leading questions, because that person is going back. He is becoming hostile or is giving a testimony that is not useful to you. The cases are State of Maharashtra versus Suresh. Supreme Court emphasized the right of the party calling a witness to cross-examine them if they turn hostile. Court held that if a witness becomes hostile, it does not support the case of the party calling them. Party has a right to challenge and cross-examine the witness to bring out the truth. Bhagwan Singh versus State of Haryana. Court held that provision enables the party calling a witness to expose the contradiction, inconsistency and falsehood in a witness testimony through a cross-examination of a hostile witness. Abdul Saeed versus Madhya Pradesh 2010. So the party calling, if it turns hostile, it can be cross-examined, giving evidence to the adverse party. Okay? Next, 137. It deals with the examination of credibility of a witness of a party against whom they are called. It allows the opposing party to cross-examine a witness in order to test their veracity. Cases are Purushottam versus State of Kerala. Again, right to cross-examine is a valuable right that enables the party to probe veracity, reliability, credibility. Now, why do you do cross-examination? Cross-examination is a tool to check veracity, reliability and credibility of the witness testimony. State of UP versus Kishan Chand. In a cross-examination, you bring out material contradictions, inconsistencies, falsehoods. Okay? Then, Ranveer Yadav versus State of Bihar. Cross-examination is to challenge and test the veracity of the witness statement, unravel contradictions and assess credibility. Section 138 now deals with the order in which the witness has to be examined. Guidelines for order in which witness should be called and examined during a trial. Okay? General rule is party who calls a witness is the examining chief first, then cross-examination, then re-examination. Okay? R. Venkatramanappa versus State of Karnataka. Discretion of the court in deciding the order of examination, it is there. Primary purpose of the provision to ensure fair and effective trial. Kerala versus Shivarajan. Since the order, determining the order, the court's powers to determine the order of examination should be exercised judiciously based on the facts and circumstances of the case. Jagdish Ram versus Rajasthan. The general rule is to allow a party calling witness to examine them in chief first. The court has the power to depart from the order and necessarily ask for a fair and efficient conduct of a trial. You can put cart before the horse also. Now, Section 141 Indian Evidence Act. Leading questions. Remember, leading question is a question which suggests an answer. What is a leading question? There are two kinds of questions, open question and leading question. Open question is where you say, what happened? Please tell me. That is open question. Whether you think this has happened, whether this has come first, that has come next, don't you think this fellow has come first? These are all leading questions. So, leading questions are allowed only in case of a cross-examination or by a party calling the witness if the witness becomes hostile. Any question suggesting the answer which the party expects to receive, which the questioner expects to receive, is called a leading question. Leading question is the one that suggests the answer, the person asking the question. Okay? It is allowed under cross-examination. They are framed as a way of a prompt only. This 141 does not make leading questions per se inadmissible. However, it highlights the nature and purpose of leading questions, which are often used to shape the testimony of a witness. Court may exercise discretion in allowing or disallowing a leading question. In Rajasthan versus Rajaram, Supreme Court held leading questions are generally not allowed in examination in chief as it interferes with the natural and unbiased narration of events. However, court recognized the leading question when the witness turns hostile or becomes evasive. In Dharampal versus Haryana, Supreme Court emphasized the leading question should be used sparingly and only when necessary. But they are, as a rule, allowed under cross-examination, where the objective is to challenge the witness' credibility or test his veracity. in Rajaram versus State of Rajasthan, reading questions are not permitted under examination in chief unless that person becomes a hostile. Okay, because the examination in chief, the aim is to allow the witness a free hand to tell whatever he knows, whatever he has experienced with all his five senses plus one mind, and then give all the facts to the court so that court will have sufficient material with it, so based on which it can proceed with the case. So that is the main aim. So in examination in chief, they do not want to put any restriction on the witness or his ability to come out with all the facts. Either he may do it before, after, side by side, sometimes in roundabout manner, but whatever manner he does, he at least comes out with all the relevant facts. The more facts that come out in the examination chief, the more facts that are available to the court, and the court can form an opinion about what exactly happened on the day of the event, because court is sitting in a place where the event has happened sometime long back, and he doesn't know where it has happened, how it has happened, and who has witnessed, who are the participants, what exactly the series of events. All these things are not known. So in examination chief, we allow the witness, whoever comes, to give his wholehearted deposition of all the details, relevant, irrelevant, everything, so that we do not want to stop his flow, and you get all the material that are required. Only then we go for other cross-examination and re-examination. So we have reached a particular stage here where sections have been completed. Indian Evidence Act, definition of evidence and relevancy rules are completed. Now an expert evidence has been introduced. Now we'll have a discussion about expert evidence and detailed discussion in the next class, because we have completed 1 hour.